I think let's then just focus on what they're covering this week, which is legislation and policy. So I think maybe as a starting point, if we can talk about how legislation and policy interact. So kind of the students might not be clear on the differences, and maybe you can use sort of mental health as an example.
Okay, so I mean, I'll use broad strokes. So when you have, I don't want to call it a problem, you have a population that needs to be served. You have a population that has healthcare needs. And so how do you make sure that those healthcare needs are delivered? And how do you regulate the delivery of these? I've already mentioned that in South Africa then, in order to ensure and to legislate to ensure that the citizenry is covered, and the obligation is on systems of governance, you then come up with pieces of legislation and regulations and eventually implementation through policies and later on guidelines. And so if you move through the cascade of a piece of legislation that is there to ensure that deliverables reach communities, reach the population or your citizenry. In South Africa, the Mental Health Care Act is what has been formulated to cover these needs, is mental health care needs. The Mental Health Care Act itself, then a piece of legislation by itself, it does not mean the services are delivered. So how do you make sure that what we say in the Mental Health Care Act, which was about a population that needs good quality mental health services or systems that are accessible and that are of such a nature that they enhance the human rights of individuals, how do you take that to the community? And then you break it up in terms of your implementation tools, and you come up with policies then that will help the system basically digest this piece of legislation and translate it from it being law to it being implementation guidelines on how the system will make sure that there is good quality access or good quality services access and efficiencies in a system. And I used a stigma as a thread that we don't always think of in terms of persuading people throughout the different layers. When you move from legislation to policy in implementation, and then your strategic planning and your monitoring and evaluation of these plans that you have, you need to continuously be checking whether the individuals or the parts of the system that you depend on are delivering the quality that you want. So stigma is one of those things that cuts across the chain, as it were. And so the legislation was meant to attend to the so-called soft parts and the human rights of individuals that were not getting good quality of care. Don't know if some of you may be familiar with the old Mental Health Act of 1973. And in that act, you used to have at the heart of the delivery of mental health services, you had the courts. The courts were involved in issuing instructions, court orders for mentally ill people to be admitted to psychiatric facilities that were far removed from their communities, psychiatric facilities that were of poor quality or delivered poor quality care. And so the Mental Health Care Act, the terms changed. Mental health care got inserted into that legislation to make sure that the care, treatment and rehabilitation part of mental health services was at the heart of it, and then to make sure that the human rights of individuals are protected. And so through the Mental Health Care Act, we're meant to protect the human rights of mentally ill individuals and to remove the stigma that is linked to this. And then through the mental health framework, you're supposed to make sure that you create systems, your so-called building blocks that are attuned to the preservation of these rights and good quality access. And then through your implementation on the ground, and your monitoring and evaluation, and your implementation tool being the district mental health system, you are to make sure then that people are taken care of in the places closest to their homes in as dignified infrastructure space-wise as possible, with good quality medication. And so I think I've already touched a lot on the mental framework, and I did share it with you. One of the biggest issues then in terms of South Africa is that that very same framework has not been updated. The strategic plan is outdated. And so we now find ourselves actually at sea. You know, we almost directionless. However, it's still a good tool for implementation, I would say.
Thanks, Funeka. So I'm not sure. The Mental Health Act is it 2002? What is the Mental Health Care Act? 2002. So you might still have been at medical school at the time, but do you have any idea in terms of the process that went on with respect to the development of that act? You know, what led up to it, who was involved, etc.
You're right. You know, we basically, as it was being implemented, we were studying different bits of it. It's like, yeah, anyone who is at medical school, or who was at medical school when protocols were being developed for HIV and things like that. It felt like that. But we're used to that in the mental health system, because we also have disease classification systems like the ICD-10 versus ICD-11, those of you who are familiar with those. So we're used to learning as we grow, as it were, and with systems that are changing. So in 2002, or before 2002, what I can attest to is that our teachers, or those who were teaching us, were involved in some of the conversations that led to the changes to the Mental Health Act, as it were. So the Mental Health Act of 1973, if I just go back to the history, had been based on archaic or old type of mental health approaches, or approaches to mental health problems. And as I've already mentioned, you had courts in the middle of this thing. And I think the human rights of the individuals brought the change, the rapid change, or the change that was then seen in 2002. We were told that it took a long time. I mean, you know, at least 10 years for the conversations to move from it is not okay to treat mentally ill people the way we are treating them. We are not providing services. They are ostracized. The entire mental health system is set aside or is treated differently to other health programs. And so it's the noise from the ground, and advocacy led to change. And the advocacy needed partnerships. So you had various stakeholders and collaborators, including legislators, and including obviously the politics of it, including law reform societies. And because a lot of it is heavily gendered on human rights, as you can see. And then apparently the healthcare specialists were called in as well, after not after the event, as it were, as an extra thought to say, hey, let's involve the specialists that are involved in this area, and let's not just involve in terms of your top-down approaches, but let's go on the ground and have a more flattened structure. And so after negotiations and talking and writing and writing, they eventually then came to a point where in 1996, when the Constitution was released, it became an imperative to no longer delay this. And so if you think about 96 to 2002, it would be, what, another 6 years for it to be in line fully, but there were a lot of pieces of legislation that were being upgraded at that time. And so it was coincidental that when the Constitution was published, then the Mental Health Care Act got also wrote into that process of amendments and reviews that would be in line with the Constitution. And so that, I think it was one of the early ones that was lauded as a good piece of legislation because it emerged in line with the Constitution. Did it make a difference in terms of human rights for mental health care users? Yes. So the first form, if you look at the regulations, and you can tell who was in the room when they were thinking about reviewing the Mental Health Act and converting it to the Mental Health Care Act. The first form is about the removal of rights by society on a person who, for a person who's mentally ill. It's the emergency admission form. You have to ask yourself, why did they start with that? And that's because that's where the biggest human rights issues were emerging, where individuals would be removed from society without really giving much of a thought and would be put in institutions far, far away from their homes and for a long time. And all it needed was a judge's signature, a non-specialist and non-medical person taking away your rights without you necessarily being fully evaluated. So the emergency admission allowed for individuals, for instance, to be seen in general contexts, that if I'm mentally unwell, I can be seen nearest my home. And if I'm that unwell, my rights will be taken, but for a very short time, 24 hours. That's an example. The legislation, or the legislators and the lawyers were in the room. The second form is about the reporting of the violation of the very same rights. If someone who is mentally ill is exploited or is exposed to a dangerous situation, and as a member of the public or person of concern or anyone related to that person, you notice this, it can be reported. The third thing that was mentioned was the discharge process, because again, from a rights perspective, you would find that a lot of us don't ever know what the doctor scribbled on that prescription chart, but it was worse for mentally ill people. So they would be taken away for a long time, and then you come back, you don't even have an idea what was wrong with you. And so to make sure that information was shared and dignity was preserved, the third form on the regulations is about the discharge. They've not even talked about your admission, but they're already worried that your dignity and rights are not preserved, to a point where they wanted to make sure that as a person who has gone through the system, you are discharged, you regain your freedom, as it were. And then the rest of those regulations are about admissions, really. But for us, we were always amazed as students, you know, why would you make an emergency admission form, your number one, your exposure to exploitation, your number two, and your discharge, your number three. And so it just showed the process that was almost in reverse from a legal and human rights perspective to then a medical model. So that's the background of the Act.